Good afternoon, Judge Shapiro. It looks like we have the reporter and representatives for both sides, which I can bring in if you're ready.
No, I want to look at a couple of things. We'll start at 1 o'clock, okay?
Sounds
Very good, thanks. Morgan, I'm ready if you want to bring everybody in.
I will start bringing them.
Good afternoon, Your Honor.
So we have Mr. Kelly here for the plaintiff, right? And Mr. Burke here for the defense.
Yes.
So, and we have a court reporter, so we're ready to go. So I'm going to call the case. It's Hinz versus U of M, Court of Claims number 21-241. And Mr. Burke, it's your motion, so you can go.
Your Honor, as always, I presume that you've read everything, and so I will be relatively brief. In order for the plaintiff to prevail, it has to have an exception to governmental immunity. The exceptions that are claimed are in MCL 691.1406, which is the public building exception, and the proprietary exception, proprietary use exception in 691.1413. I don't think that there's really been any argument on the proprietary use of the med-in. Plaintiff did not respond to the short brief that I put in, and there's been no evidence that this was the med-in was made for, was operated for pecuniary gain. And I think it's clear from the record that is in there that this is not. So, moving to the section 1406, the public building exception, there have to be two things that the plaintiff must prove in order to invoke that exception. First, there has to be a dangerous condition of a public building, not just in a public building. And secondly, there has to be certain notice to the governmental entity, in this case, the University of Michigan. We don't believe that they have satisfied either of those issues. Let's start with the dangerous condition. Plaintiff has used almost all of their brief in discussing the notice and the condition that exists when in the med-in, where there are rooms that still contain tub liners in the bathtubs. And if that was the issue in this case for this fall, plaintiff would be correct that that would be an issue of fact. But the problem is that room 519, where this accident purportedly occurred, did not have a tub liner. It had been removed several years before this accident, and there is absolutely no contrary evidence to suggest that room 519 had a tub liner at the time of this accident in April of 2021.
Mr. Burke, let me interrupt for just a minute.
Sure.
I have puzzled over this issue of liner and glaze all weekend, and it seems to me, again, I'm not a maintenance worker, but that as I read everything, it seemed to me that the concern about the liners was that water was getting between the liner and the bathtub, causing an uneven surface. It was apparently lifting, I don't know which side, but something. And that the concern reglazing was this bubbling and peeling. I don't see how a liner could peel. But again, it's not my area of expertise. But so I know we've been talking about a liner, but my sense is that this is really a case about the glaze. Can you speak to the difference at all?
Yes, a liner actually completely lined the tub, and there was space where on the wall side, so to speak, where water could intrude, get in between the liner and the surface of the tub and cause the problem. And that is a problem that U of M realized was dangerous, and has, as those conditions have occurred at various rooms, because it's not always happening, that they have then taken those rooms out of the rotation, or not allowed patrons to be in those rooms. Room 519 apparently was one of those rooms where the liner was a problem. And Ms. Nolan testified that in between 2015 and 2017, that liner was completely removed. And that this new substance, this miracle method, which obviously from the pictures was not much of a miracle, was just glazed right on top of the tub surface. So when you are looking at the pictures that show a gray and a white, the white is the miracle method, and the gray is actually the tub surface, the physical tub surface. And so because of that, the issue is whether or not in this room, the glaze on the tub surface was a dangerous condition. And there is no evidence that the peeling of the glaze created a slippery condition that was more slippery than any tub. And that is exactly why we had our expert, Ms. Yake, go in and test the tub to see whether or not having areas that were uncoated made those areas more slippery than the coated areas would be, because there's no claim that the coated areas are dangerous or are too slippery. And the undisputed evidence from her testing is that they are not. In fact, they were slightly less slippery. And there is no contrary evidence to that. The plaintiff, Mr. Kelly, cross-examined Ms. Yake and described certain things. So he may be able to to argue credibility. But the problem is there is no other contrary evidence to show that the surface, glazed or unglazed, made it more slippery and therefore dangerous. And so that is, in essence, our very straightforward case is they have not shown that the condition that existed in the tub at the time of the alleged fall was a dangerous condition. Secondly,
let me stop for a second.
Go ahead.
Because I just reread plaintiff's deposition to try and get an understanding. And the way I read it, and perhaps I'm incorrect, I will have to look at it again, is that the floor, the area on the floor of the tub that the photos now show as peeled, the gray area, was not peeled when he stepped into the tub. So my reading of what he's saying is that the peel actually came off while he was in the tub, which I think would be a different matter in terms of how slippery it is. In other words, the surface doesn't have to be slippery if the surface actually, slips off itself. Do you follow me?
I do, Your Honor, and I understand that is his testimony, and that dovetails exactly into the second part of the requirement of 1406, is that there had to be notice of this. And if the plaintiff's testimony is accurate, and that when he stepped into this tub and got both feet on the surface of the tub and was standing there, there was no evidence of peeling, of this miracle method being peeled, and that it happened during his slip and fall, then there is no notice that the university had that this particular tub was in any way slippery, because there was, in theory, no areas of the surface that were unpainted now. And so this would have, in theory, been the first evidence of a potentially dangerous condition, assuming what you're saying, which I understand, but there is no evidence that the university knew that could happen in this tub, and especially that it could happen, in theory, to cause somebody to fall. we do have some issues related to that testimony and whether it makes sense, but those would, in theory, be factual questions.
And indeed, whether he fell in the tub at all.
Correct.
Yeah.
And so that's, and by the way, Ms. Nolan testified that they had no notice in that room 519 in any way, had any problems prior to this occurrence. And so, between those two things, we don't have any disputed fact that would allow the court to find that the university meets the exception in 1406 and failed to properly maintain the tubs. And we go back to the fact that, in theory, the tub, it's not more slippery regardless of which way you do it. And finally, there's no evidence from the plaintiff that the condition was actually dangerously slippery or dangerous. He simply says, this is what happened. And there's no expert that says, sorry, this is you can never have this kind of a condition in the tub. So that's it, Your Honor.
Very good. Let me think for just a second if I have any questions for you. Okay, no, let's hear from Mr. Kelly, and then you can give rebuttal if you like. Go ahead, Mr. Kelly.
Okay. You hear me okay?
Yes, I can hear you. Thank you.
Okay, I'm sorry.
Can't hear you.
Now I
now.
can.
We can't hear you at all.
Kelly? Now I can hear you. Now I can.
I'm gonna call in so that I don't have this issue.
Okay. I don't know where you're calling into, but I guess we'll find out.
While we're waiting, did Lansing get the ice?
Well, I'll tell you, my home in Ann Arbor is freezing and dark, but the drive here to Lansing was totally easy, and the roads here are fine, and they seem to me fine in Ann Arbor too, except for the trees and stuff that had fallen down.
Right. Yeah, I just was wondering if it wasn't clear to me on watching the weather yesterday, whether Lansing was getting anything other than rain. So.
Yeah, and I plan to do this from home, but I have no power, so happily the roads were passable.
Well, we had power in our area, but I did see there were some areas that did not. So.
Let me just ask you, Mr. Burke, off the subject, are you in the show this year at Burns Park?
I am not. I'm backstage, and it's this weekend.
I saw the sign.
Tonight is actually opening night, so at the Michigan Theater. So.
Can you guys hear me now?
Yes.
Yes, I can hear you, Kelly.
Okay.
So
Sorry
we didn't
about
hear
that.
again what you said, so you just have to start over, please.
Okay.
All we heard was, can you hear me? And then you went out. We didn't hear anything else.
All right. So, Your Honor, I had the same question after reading the defendant's reply brief, what the difference is between a liner and a glaze or paint or whatever the material, the miracle method is. But the key here is not necessarily what the words actually mean, but how the defendants use them. So, for instance, on June 6, 2019, Carly Nolan, the general manager, and this is Plaintiff's Exhibit 4, writes an email to the University of Michigan, other individuals in the organization, that says the following tubs are peeling up. I have taken pictures, however, the email is not coming through. I can text them to you if you like, or I can try again on Monday. Then the following tubs have water between the tub and the liner, creating a safety hazard. Now, and then it lists 5 rooms. The same day, June 6, 2019, and I didn't attach this to the response, but I'll be happy to supplement with this exhibit. But the same day, Ms. Nolan emailed herself photographs of several tubs from the rooms. One of them is 530, the same tub that is referred to as having peeling, it's peeling up and has a tub liner. And when you look at the tub, it's not a tub liner like a hard acrylic plastic that we would normally think of a tub liner that goes over it. It's the same glazed, painted tub that's at issue in 519. And so you have the defendant's own individuals referring to tubs that just have glaze as having a liner. And the question here is, was water seeping underneath the liner, the glaze, the paint, whatever coating, however you want to refer to it, was water slipping under there? Did it create a slip hazard? And did he slip on it? And did they know about it? So you look at the plaintiff's testimony. He testifies when he fell, he's watching the water coming from the shower hose onto the coating and slipping behind it, seeping behind it. That's what he identifies that he slipped on. Now, you look at, is that a dangerous condition? Well, Ms. Nolan says it's creating a safety hazard. You have all these emails that they produce where they're talking about these tubs, where they know it's creating a safety hazard. We need to find a way to drain the water. We want to replace these, but U of M's not paying for it. Okay, so it's the same problem in all these rooms because they took the tub liners out, the hard plastic tub liners out, as they said. So we're dealing with this glaze, whether you call it some plastic material, coating, whatever. The issue is, was it dangerous? They're saying it's creating uneven surface. It's creating a safety hazard. It doesn't matter what the plaintiff says. The defendant's own witnesses, their own documents establish a factual dispute on that.
Well,
Now,
it doesn't establish a factual dispute as to 519, does it?
Well, it does, because Ms. Nolan testified that she knew, or that they knew, what rooms had chipping, peeling, coating. And so if they know that the chipping paint is allowing water to seep under, not only that it's seeping under, but it's creating a safety hazard, and they know that there's chipping paint in there, that's a very logical inference that they knew that this was a potential hazard in that room. But we don't have to show actual notice. We can show constructive notice. And so they've known for 10 years plus, based on their own emails, that this was a problem with the tubs, that they've confronted it in, numerous rooms. They wanted to replace all 30, but they didn't. That there's chipping paint. It's the same type of chipping paint in all these rooms. And they're going in and out of these rooms. They're cleaning the bathtubs. There's maintenance. There's housekeeping. Ms. Nolan testified that she would go in and out of these rooms. Based on those facts, I think there's a factual question of whether they should have known that this was a safety hazard. But I think we don't have to reach that issue, because we know, based on their emails and testimony, that they knew there was a safety hazard. They knew that water seeping under there was creating a safety hazard. And what they did, why there's not conversations about all the tubs, is because what they did, specifically in 2019, when she presents these photographs of these tubs, they're telling her, find the worst ones. Maybe we can get a few fixed at the time.
Mr. Kelly?
So, yeah.
Stop you for. I have a bunch of poor but color Xerox photos of the tub. I'm not sure which were taken by a defense expert, which were taken by the plaintiff's friend, but do I have the ones that you're referring to that were emailed to Ms. Nolan?
No, you don't. And that's, I'd like, if I could supplement the record by submitting that, I would be happy to.
Tell me what you think they're gonna show me. I know you mentioned it, but tell me again.
Yeah, there's about 5 different tubs, I think. I can give you the numbers. It's like 506, 512, 516, 527, 526, and 530. And basically what those tubs show, or the photographs show, is various tubs in different states of peeling, chipping paint on the tub surface.
Okay.
And, some are worse than others. It looks like some they've tried to rip some of it off, like so to try to make a smooth thing. Some of it looks like the paint has just chipped and it's sort of creating like a pyramid with a middle in it. That this is what the concern is. And that email that she's referencing, those photographs that you can't send to them, is what she says the liner and the tub, water getting in between there, is creating a safety hazard. She
That's
continues.
the June 6th at 1513.
Say that again.
I'm sorry. Are you referring to the June 6th at 1513 email where
Yes,
she's
I am.
writing? I'm not sure who she's writing to. Okay, and there were
Alfredo
photos
Brooks.
attached to this email that I haven't seen.
So there's a second email where she sends herself. So it's from her personal Yahoo account to her U
Is
of M.
it in the exhibits here, or you're telling me about something that I don't have?
It's something you don't have.
Okay. Is it in the record to date?
No, it's not.
Okay, I'll think on that. You can continue.
Yeah.
Do you have anything else?
And really the only relevance I think comes up if they're challenging that there's some difference between the reference to liner or glaze. And so I think that Exhibit 4 shows that Ms. Nolan is referring to the glaze as a liner because she's saying those tubs are peeling and that water is getting between the surface and the liner, but there's no hard plastic liner that we would think of, or normally when you think of a liner.
Mr. Kelly, has anyone inspected the bathtub on behalf of the plaintiff?
No.
Okay, you didn't request an on-site inspection.
No, I mean, there is photographs, and I think the plaintiff's testimony was clear that he observed water going in, seeping in between that. And certainly,
Okay.
I think with these emails where they're talking about for years that water seeping in between there, what else do I need to show? They're aware
I'm not
that
telling you did anything wrong. I just wanted to make sure I, okay?
Yeah. But I think that's the argument why they're on notice, because they knew that this was a condition that was happening in multiple tubs. They knew that this tub had the same characteristics, and they're admitting that it's a safety hazard. And in fact, there's emails that after this fall showing that other people were falling. Somebody else fell, chipped their tooth. Okay? So this is something that they've known about. They've tried to fix it, and they just didn't have the money. And, I guess lucky for them, they have enough demand that people will keep renting the rooms with that type of tub. But you see this is a government agency not wanting to spend the money or not having the money to spend, but continuing to rent out these rooms knowing that there's a safety hazard. That's negligent. And that's, them to get in and say, you have an expert that says if you're standing perfectly still on the tub surface and you're not moving, well, actually the unpainted area is more slip resistant. But that's not the real world. We're dealing with people that are moving, that are stepping into it's kinetic. It's not stasis. They're not just standing there. It's not static. It's a movement.
Well, actually, it sounds from his testimony like it was static, but okay.
I guess I would disagree with that, but I guess obviously that's the court has.
That's fine.
Right. Your interpretation is what matters, I think. But I would think either way, the question here is not whether he was just standing there or while he was stepping in he slipped. The question is, did the water seep in there, create an uneven surface, and did he slip on that? And that's not what the thermometer that they use measured. It doesn't help us with anything.
Do you want to say anything? Sorry, continue.
No, I was just going to summarize that. I think, there's a dangerous condition, and that they had notice of it.
Okay, and I assume that your position on governmental immunity is that the tub is a fixture and therefore it falls within public building. And do you abandon the proprietary claim?
Yeah, I never read my complaint as trying to raise it, and so that's why I didn't respond to it. So to any extent that we did, I wasn't trying to advance it.
All right, very good. Mr. Burke, any response?
Yes, really quickly, because I forgot something in my first argument, is the only area where Mr. Hinz testified that there was, quote, water seeping in was this crescent-shaped area on the side of the tub. There is no evidence that anything like that ever existed. The pictures of the tub do not show any crescent-shaped area on the side of the tub in any photos. And we have photos that Ms. Yake took a year after this accident that show no deformity or any area on the side of the tub. And the plaintiff has not even established how, if that existed, that then created a dangerous condition on the floor of the tub that caused him to fall. And so we don't have any connection, and we don't have any actual evidence. I mean, we do have the plaintiff's testimony, but even the photographs that his friend took don't show any crescent-shaped area on the side of the wall. That would be potentially something that might occur if there was a tub liner in there, because there would be a way to get in between that. But we're talking about a glaze. This miracle method stuff is just a glaze. It's like paint that's on top of this bathtub. There's nothing that shows water is infiltrating that would cause a dangerous condition. That's all.
And all right. Mr. Kelly, just do you want to say anything about the crescent and whether it's in the photos? Because these photos are not easy, but he makes a point.
No, but I think whether it's displayed or not, what was the condition when they're taking the photographs? No one's taking the photographs with the shower on. So how the photographs don't tell us anything, because it doesn't tell us where the water's coming in, if water's coming in. It's apples and oranges.
All right,
I think you have his testimony, and that's what there is. I guess they can contradict it.
So, Mr. Kelly, here's what I'd like to do, and Mr. Burke. Mr. Kelly, I'd like to see that email and attached photos. I'd like you to file it with a not more than one-page statement of what you think it purports to show. Let's say maximum of 2 pages. And then, Mr. Burke, I'll give you, if you'd like, an opportunity to respond to his statement about that, what purports to show. And Mr. Kelly, can you get me that? Today is the 23rd already. Can you get me that by next Wednesday?
Absolutely.
The 1st? All right. And Mr. Burke, can you get back by Monday or Tuesday, the 6th or 7th?
Sure. The 6th would be better.
Pardon me, sir?
The 6th would be better.
The 6th would be better. Okay, very good. And I won't rule until I've had a chance to look at those. So I don't plan to issue an order unless either of you want to see one. I'm happy to do it if you think we need it, but otherwise I just expect to see the materials the email, the photos, and the brief statement from Mr. Kelly, what did I say, by the 3rd? And the
first.
response, the 1st, pardon me, thank you. I'm glad someone's listening. And then the 6th for Mr. Burke to send me the brief page or two response if he wishes.
Sure.
And I will promptly after I get them, okay?
Okay. Thank you.
Very good. Thank you. Anything else?
No.
Nothing, Your Honor.
All right, very good. Thank you both. And
Thanks.
this hearing concluded.
Thanks.
Thank you. Have a good day, y'all.